All right, good morning, everyone. Welcome to the University of New Mexico Law and Mental Health Series, weekly discussions of practice and science by experts in behavioral health and the law, hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're so glad you are all here to join us today. I'm Cassie Brown, Forensic Psychology Postdoctoral Fellow in UNM's Department of Psychiatry and Behavioral Sciences and its Division of Forensic Behavioral Sciences. For our talk today, please ask questions you have for our presenter in the Q&A, not the chat box, anytime you feel comfortable. Just know we hold questions until the end of the talk. Also, we try our best to get to as many of your questions as possible, and please forgive us if we do not get to yours. If you're pursuing continuing medical education credits, the sign-in sheet will be available in the chat shortly. If you're pursuing APA continuing education credits, the link for the survey you'll complete for credits will be posted around the last 5 minutes of the talk. You have to save your certificate after you have completed the survey because we don't keep copies on file. And the recording link and PowerPoint slides for this talk should be available sometime later this week. For next week's talk in the series, we have Dr. Michael Gottlieb and Dr. Jeff Youngren, and they will be discussing clinical ethical considerations surrounding multiple relationships in forensic practice. But let's get back to this week. I'd like to introduce you to today's speaker, who will be discussing procedural issues that can bias our judgment in forensic evaluations, Dr. Anthony Perillo. Dr. Perillo is, of course, the usual moderator for this series and is an associate professor and the training director of the University of New Mexico's Forensic Psychology Postdoctoral Fellowship. He's a licensed psychologist who has conducted forensic evaluations at the private practice, local, county, and federal levels. And for the last 7 years, he's supervised clinical trainees in clinical, forensic, and police evaluations. Dr. Perillo has received several honors from the American Psychology Law Society, including a first-place dissertation award for his research on risk assessment of sexually abusive clergy, and the Early Career Teaching and Mentoring Award for his work with forensic trainees. Dr. Perillo's ongoing research focuses on factors that influence clinical judgment in forensic evaluations. As co-PI on a project funded by the National Science Foundation, he recently completed a project with Dr. Jen Perillo, examining cognitive and legal factors that lead to biased forensic evaluations. As an advocate of making forensic research more transparent, accessible, and trustworthy, you can find Dr. Perillo's paper on open science practices with Melanie Fessinger, Brad McAuliffe, and Jen Perillo in the recent Oxford Handbook of Psychology and Law. Dr. Perillo, on behalf of the rest of UNM, we're thankful to have you sharing your expertise with us today. I'll now turn it over to you.
Well, thank you so much, Cassie, for that introduction. It's been, Dr. Brown there has been an outstanding forensic postdoc here so far at UNM, and I've been thrilled to work with her. Today, I wanted to go over some work on procedural factors that can potentially bias our judgment when doing a forensic evaluation. This has been an area that I've been researching with other colleagues for a while now. And my long-term professional goal had been just basically to leave forensic evaluation a little bit better than I found it in the big picture of things. I had been doing a lot of research, less clinical and forensic work until I joined UNM and started directing the postdoctoral fellowship here a little over a year ago. And I wanted to update a lot of things that I've been thinking about in terms of recommendations for procedures that can reduce evaluations based on some increased exposure and my return to forensic work. I've seen more and more how some of this can work in practice, talking to forensic clinicians, and now directly from a lot of my evaluations. The goal here was, seeing firsthand some of the issues that can factor in how that might interplay and impact our evaluations. So overall, the goals of this talk is to describe some aspects that are inherent to the evaluation process itself that can increase risk for bias. So we're not talking about bias in terms of bias toward individuals based on demographic information or personal beliefs, but more so about biases that just from doing an evaluation in the system that we do, how that can promote bias across clinicians, across evaluations. Then from that, explaining cognitive factors that we're all susceptible to that can bias our judgment during forensic evals. And then looking at what we know so far in terms of potential strategies that can address bias, and looking at these and separating the intellectual theory versus what might be a challenge to actually implement in our day-to-day work. And like I said, I'll try to sprinkle a little bit through one particular example that's come up this past year of how we can see different challenges in addressing bias in our evaluations. Now, ethically, the APA specialty guidelines say we're supposed to strive to be unbiased and impartial. When we are doing forensic evaluations, we're still generally in a helping field, but the help here that is a little bit different. We're not supposed to be advocating for a person. We're not necessarily providing a therapeutic service here. We're being asked to provide information that courts want to be objective. They want factual information to help others make a factual judgment. Strive to be unbiased and impartial is doing a lot of heavy lifting here because, as the specialty guidelines also point out, they acknowledge the inherent struggles in the adversarial process of the U.S. legal system and how that can pull at our strings to be biased and impartial. I'll go ahead and just say I would argue that objectivity and impartiality in a forensic evaluation is impossible. We are humans doing human work and prone to the same biases that everybody else is. Even if we have data that we are calling quote unquote objective, we are still subjectively interpreting that information or subjectively weighing that information in our opinions. So ultimately, can forensic evaluations be objective? I would argue they ultimately cannot if we're talking about an absolute perspective. They can't be 100% impartial. Can we reduce that impartiality? Certainly. The goal here is to minimize the outside noise that influences our judgments in order to be as precise and accurate as possible. So how do we do that broadly? It's way easier said than done, but the steps would be basically, one, we need to acknowledge these biases that are inherent to our practice. We can't address them until we acknowledge they exist. Then we need to know not just that they exist, but why they exist. And from there, once we actually understand not just that bias exists in evaluations, but why they do, then we might be better able to identify techniques to reduce our vulnerability to biases when we're doing an evaluation. Bias in forensic evaluations has been under a microscope for about the past 15 years or so, particularly the concept of adversarial allegiances, which I'll focus on a lot during this talk. And for those of you that are a little less familiar with adversarial allegiance, there have been a lot of research studies on it. One of the principal ones looked at an experiment where clinicians were undergoing training for risk assessment tools. They thought then that as part of this free training, they were doing a consultation and practicing using their skills on the static 99R and the PCLR to score measures for a consulting firm. What they didn't know is they were actually part of an experiment where they weren't actually doing these consultations for real life people, but it was an experiment where they were either told that this firm that they were doing the consultations for was framed in a defense-leaning way, where they were basically trying to demonstrate that not all defendants have high risk of sexual offending. So if you could score these measures for this person, we would really appreciate it. And then the other half of people got a more prosecution or state-leaning framing, where they say we're part of a firm that tries to highlight the particular risk or dangerousness for certain people. Again, they didn't ask them to make certain findings in favor of their side. They just framed what their consultation firm was about. And what we indeed saw in that study is that you take people that had gotten the same kind of training, they hadn't chosen to work for one side or the other, manipulated an experiment. We saw this effect of adversarial allegiance where defense experts tended to score in ways and interpret instruments that favored a defense-leaning argument, that lowered risk, lowered PCLR scores. And people that looked at the same data, that came from the same background, but had a prosecution-leaning frame of who the firm was that they were looking at these scores for, scored risk assessment measures a little bit higher, saw more psychopathy in these individuals. We've seen this concept, we've seen these trends in other kinds of experiments and other kind of field data. There have been analysis of field data, for example, where you look at people's evaluations of sexually violent predator commitment, and in looking at what norms evaluators chose to highlight in their reports, even in those, we saw that defense-hired experts tended more often to report recidivism rates and risk assessment scores using routine sample norms and 5-year rates, which are lower rates than, say, 10-year rates, because 10-year reoffense rates are always higher than 5-year rates, or at least they can't possibly be lower, right? So we saw prosecution experts on the flip side more commonly using 10-year rates and high-risk rates. So we see this bias as inherent part of the process of the data that we present, as well as our overall impressions. And this concept of adversarial allegiance is the tendency for all of us to give judgments that favor the side that requested our services. This is based on a concept of forensic identification that's been around for several decades, even though the concept of adversarial allegiance is more consistent here, or more recent here. Forensic identification is this idea that we identify with the side that referred us the case, and so we fit the case into the narrative of our referral source. What I want to emphasize with adversarial allegiance is that we're talking about unintentional biases, our tendency to unintentionally interpret things in favor of the side that requested our services. And what this tells us most likely, and what research has since suggested, is that you don't even need to explicitly know your source to favor that side. So it's not necessarily about an explicit outside pressure to comply with the side that hired you. But even in a court-ordered evaluation, sometimes you know the context of how that evaluation arose. I know in some of my roles of doing court-ordered evaluations here, a lot of times we'll get the information about who requested the evaluation. So even though it's court-ordered, we know what side wanted it. And by knowing that information, I still know who requested my services. And we're still prone to the risk of delivering findings in the way that that side wants, or giving that side the benefit of the doubt, more than the side that didn't bring up the issue to us, even if, again, we're not in direct contact with that side. Now, initial reactions to adversarial allegiance, there was a lot of pushback about the concept and a lot of attempted rationalization. And it's understandable that we would not want to think in our field that we are prone to this bias, but we are. A lot of initial reactions to this was, well, in the field, the reason that we see these disagreements are because it's a strategy by attorneys. They know who's going to favor their side, and so they hire people that are biased for their side already. Now that's true, or that's not necessarily untrue, is probably a more accurate way to say that. But that's more an explanation of the playing field of what can exacerbate this issue further. It doesn't explain why people would still fully evaluate for the side that retained them, but it might tip the scales to make sure that we see that side. Some people thought it was strategic by evaluators. I would liken this to a lot of things where we've seen the argument in law enforcement of a few bad apples. It's the same kind of argument where people were saying, well, that is a few implicitly or explicitly biased evaluators. It's not a broad issue. We've seen through the experiments, it is a broad issue for forensic evaluators. We are human. We are prone to human biases. And similar, people would say, well, yes, this is an issue for forensic psychologists. I'm less biased than my colleagues. You're not. I'm not. We are all prone to these things. And so it's really important for us to acknowledge that so that we can understand and address those kinds of issues further. So issues inherent to our forensic evaluations that can promote bias here. Oftentimes you get contextual information about why an evaluation has been requested. And oftentimes in that contextual information comes an expectation from one of the sides. If there are concerns about a defendant's competency by the defense lawyer, there's an inherent context there where the defense lawyer is expecting you to find in a way that identifies the same concerns that they did. And so that increases your implicit nudging toward a finding of not competent in that particular scenario. Most of the times our forensic evaluations are referred from a particular source. That affiliation can increase our biases, whether it's explicit or it's implicit. Sometimes we want to do a good job always in our psychological services. And so if somebody refers a case to us, we want to do a good job. And although for us in the field, the job is supposed to be factual and objective, we're still in a helping field, and there can be a nature to want to do a good job for the side that you have developed a professional connection with and affiliate with. And as we'll discuss later on in these slides, early information can shape our impressions. So this contextual information that we get early on in an evaluation, it reduces our ability to really enter an evaluation from a pure blank slate. And so the idea here is that we might be a little bit biased already in an evaluation before we even start it, based on the context and our understanding of why we're being asked to do the evaluation of the first place. And I think that's a really important thing for us to acknowledge here, is that there can be some implicit expectations of what to find, and we can be vulnerable to look at that. And these next couple of slides here, where we get into more of the cognitive explanations of forensic bias, we'll look into that why. Now, before we do that, I wanted to bring up a scenario that might be highlighted a couple of times through the rest of this talk in terms of cognitive explanations and solutions for forensic bias. Let's say you were asked to do a competency to proceed evaluation. It was court ordered, so it's technically, you're not being hired by the defense, you're not being hired by the prosecution, you're being hired by the court. You also know that this is a second opinion evaluation. So you haven't seen what the initial evaluation was, but you know that a prior competency evaluation was done. You are being court ordered to do another evaluation. You know that the initial motion based on the court order is by the defense, that the defense asked for the evaluation, prosecution stipulated they didn't object to this. So we're going to go ahead with the court order. And before you do your evaluation, because this is in a second opinion, you have access to that initial report. What I want you to think about, and this is what we're going to put up a poll here in a bit, is if you have access to that first report, when would you look at it? Would you look at it early on before you've even done your clinical interview with the defendant? Would you do it in the middle of your evaluation, sometime after your interview, but before you've actually reviewed everything to form an opinion? Or would you do it as like one of the last things there to form an opinion? And so if we could put the poll up so people could respond to that. I'll give it a little bit of time. Take a little water break here just for a little bit more, and then we'll stop it in a second. Okay. We could go ahead and close the poll, and if we share the results, I don't know if I can see them, but okay. So half of the people that responded said they would do it at the beginning before they have done their interview. We had 29% saying they would do it late, and 21% doing it in the middle. Now, so we don't have a consensus here, and I'm sure a lot of people have particular reasons why they might do it one way or another. Feel free, whether entering in the chat or Q&A box, any particular thoughts of why there might be a compelling reason or why you would want to do it early versus middle versus late. The question is ultimately, does it matter? It very well could. It could it could influence your opinions for better or worse when you look at that initial report. But we also want to consider the purpose of reviewing that report. So before we review the initial report, I encourage us to think about what we're looking for in that report. And some of you very well may be doing that already. I hope a lot of you are doing that. But I would think about not just, oh, let me look at what's in that report, but think about what information you're looking for from that report. Are you looking for what the evaluator thought about the person? Are you looking for how the person presented? Are you looking for what's been done? Think about that before you actually review the report, and it helps you, it will at the very least help you focus in what could end up being a massive report on the critical elements that you wanted to use that report for. Now, I'm going to provide some additional context to this scenario that I gave you. I didn't want you to vote on this particular aspect, but the reason I brought up this scenario is because it came up in my first year here as the forensic postdoc supervisor with one of my postdocs. And so the evaluation was actually to be done by my postdoctoral fellow. And the postdoctoral fellow knew who had done the other evaluation, had not seen the report yet, but knew who had done it. And the other evaluator was very well known in the field, very well known to the fellow. And the fellow came and consulted with me about whether she should look at this report or not beforehand. And she flat out said, I don't know if I can disagree with Dr. So-and-so, because I really respect Dr. So-and-so. And there was a little bit of imposter issues going on with my fellow. They were very acclaimed here, but basically saying that psychologist knows way more than me. I don't know how I can look at the same person and say that that other psychologist is wrong. So I feel like if I look at this report, I'm going to be biased before I'm going in to basically agree with the initial psychologist. This is a really important thing to acknowledge, and maybe not all of us would feel that way during the evaluation. In fact, there might be some situations where we feel the other way, where we know the psychologist and we might expect to disagree with them given the context. Either way, that could potentially bias us. Now, some common factors that can explain bias in forensic evaluations. One, our ignorance of this. And this is why we get to this idea of we need to acknowledge bias inherent in forensic evaluations and the adversarial process in order to be able to address it. We all have what has been colloquially called a bias blind spot. I'm looking for other kinds of language that is a little less ableist here. I look at bias ignorance here, this idea, this internal ignorance that we're way better at seeing other people's biases than we are at seeing our own. Now, this doesn't explain why bias happens, but it does help explain why bias persists or why it may be maintained. We are very better at judging bias in other people better than ourselves. Why? Well, part of that is because in order to look at our own bias, we need to introspect. And this bias is usually unintentional. Oftentimes it's non-conscious. So it's hard for us to identify what we can't actually see. We also tend to assume that our perceptions are directly reflective of reality as people. It's what we call naive realism, that we're naive to the idea that what we see is what is actually out there in the world. And so that we perceive that if somebody sees something differently, they're the ones that are wrong. They're the ones that are biased because I saw it with my own eyes. I heard it with my own ears. I saw the truth. We tend to, it's hard for us to address what we don't see. And we tend to see biases better in other people the more that we see them as an outgroup. So psychologists are better at seeing biases than psychiatrists. Psychiatrists are better at seeing biases than psychologists in an overgeneralization. We even see rationales when we look at experience levels and we look at this kind of bias and we ask forensic clinicians in the field, who do you think is more biased, the early career evaluators or the seasoned vets? And you see seasoned vets will say, well, early career people don't have as much experience, they don't have as much training, they're more prone to these biases. And early career people will see the more seasoned people don't keep up with the literature as much and they get set in their ways, they're more prone to bias. We can rationalize why other groups that we don't belong to are more biased than our own. And so I was appreciating how my postdoc here was considering how reviewing the information could affect it. She would not be able to address this bias if she weren't even at least acknowledging that she could have this bias if she reviewed the initial report before she did her evaluation. Now, factors into what can produce this bias. Well, many of us are probably familiar broadly with cognitive dissonance, and it's this idea that we as humans love consistency. And when there are some tension or conflict between what we think and what we see, that can cause some tension within us. And so we know as forensic evaluators, we are supposed to remain impartial. When we're referred aside by a case, we know that that side is not impartial, and we are working for a side, or we have been asked to work for a side. And so there can be this internal conflict. Well, I'm supposed to be fair and objective, but this side wants me not to be. And how do we reduce that bias? There is a motivation for us to reduce that tension in us between some external demands to be impartial and our internal demands, or the demands of our organization to be impartial. So the easiest way for us to reduce that tension is for us to see the evidence that agrees with that side, that it's not that I'm being impartial, it's not that I'm being partial and biased for that side, it's that the evidence points to that side. That side wouldn't have brought this up if there wasn't evidence that suggested the findings would lean their way, and I have found that. And so we reduce that tension with us by being motivated to find in ways that support that side. This is a natural tendency in a lot of different forensic psych and a lot of different general psych kind of ways. My trainee was basically saying they didn't know if they could disagree with a prominent psychologist. The cognitive dissonance here would be that there is internal motivation for that person to find evidence that supports that other psychologist's opinion, so that by the end of her evaluation, she would feel better because, oh, it's not that I'm biased, it's because that's what the evidence points to. And so we have a motivation to then find the evidence in a way that would support internally what we want to unconsciously find. And so it's really important for us to acknowledge different motivations that we might have in order to reduce tension about the idea that we're supposed to be impartial, but we have all these different forces that try to sway our opinions one way or another. Now, anchoring is a factor that says early information that we get tends to shape our expectations and our judgment more so than later information. If you've ever been involved in trying to resolve a fight between two friends or two siblings, and you get one side first, the one side comes to you and tells their side of the story. If you've ever been upset at the other person before you actually even heard their side, you've been anchored to have expectations because everything was framed from a particular lens. And so you haven't, before actually hearing the other side, you're going in with a pre-existing idea of what happened. That's you being calibrated to support the early information that you have. In a forensic evaluation, oftentimes the contextual referral information, we are vulnerable to be anchored by that side where we're not actually coming into an evaluation with a blank slate. We come in with a blank slate for one side that didn't give us the referral information. But for the other side that got information in there about, I've had trouble working with this client, and I'm really concerned about their memory of the alleged offense, and I'm not sure if they're competent. You are being anchored. You're not fully going in with a blank slate. You've been calibrated in a way with contextual information before your evaluation that leans one way rather than looking at things more holistically. Now, some of that information might be very relevant to your case, and it could be vital. The question here is not whether that information is relevant and factors into your opinion. When we talk about bias, it's how much that information factors into your opinion relative to all the other information that might be available. So this was one concern that my postdoc had in terms of reviewing the initial report, was that she would be calibrated if she saw the other psychologist's impressions of the person and their finding on competency, that she would be calibrated to look at things that way. Now, somebody could argue that if you were doing a second opinion in another context and you knew who the evaluator was, and you had seen or disagreed with them in other cases, you might actually be anchored the other way, where I know the context is I'm being asked to do a second opinion evaluation. Well, what does that mean? Well, it means that people in the case have a significant disagreement. I'm sorry about that. This is a guest. I'm not in my normal home, so if there are buzzing, that's a little out of my control. That but with the second opinions, there comes an inherent expectation that there's a reason to disagree with the initial evaluation. So by knowing I'm doing a second opinion evaluation and then seeing that finding, I might actually be anchored to think I'm supposed to be finding why this person's wrong. And so it might actually anchor me in the other direction. Rather than agreeing with the psychologist, I might be prone here to find ways to disagree, because clearly the court is expecting some sort of, it's not a clear-cut case, otherwise the court wouldn't be asking a second opinion. At least that's the shortcut we have in our minds. Now, anchoring in and of itself is a foundational aspect that can shift our biases. Early information that we get can shape our interpretations. So that early information we get, it depends, whether we decide to look at that report first, that can really anchor us, versus if we do our clinical interview, that early information from the clinical interview could anchor us too. The big part of what then propels bias in our evaluation is the concept of confirmation bias, which is promoted by this anchoring. Basically, all of us as humans, we don't like to think of ourselves as being wrong. So naturally, mentally in our heads, we spend more time looking at the world in ways to try to see if we're right. When we have an idea about why something exists or why something performs in a certain way, we test it to see if it's right. We don't usually test to see if we're wrong. And that's what confirmation bias is. It's our tendency to then search for information or interpret information in a way that will prove that we're right. So our early impressions of a case based on how it's been framed or how it's been anchored makes us vulnerable to looking for information that gives us a way to support those early inclinations. So when we think about bias, if we get information during the evaluation that contradicts our initial impressions, we don't necessarily automatically ignore or downplay that information, but we're motivated to do so. And we have a tendency to more strongly downplay that evidence or to ignore it. If you've ever noticed that you were looking at collateral records for consistency with severe mental illness, and there was a medical record that didn't have that illness, you might be quick to go, well, they just didn't cover it, or, oh, they missed it. Or you might even just go, they didn't have it. Oh, well, and you just move on, without sitting and giving the weight of what might it mean that there was another evaluation or other mental health records or medical records where this idea that I have that this person has a severe mental illness, in these records it said it doesn't indicate they have that. Why might that be? And we don't really sit and process with it as much as we do information that supports us. That's a subtle example of confirmation bias in action, where it's not that we're flat out saying, I am going to ignore this, but mentally we spend less time with it. We spend less effort processing it because it's not supporting our narrative. We don't find it helpful because we're looking for ways to be right. We tend to see supporting evidence as stronger evidence. So if we find, in those hospital records, there was a diagnosis that was in line with my impressions, I might remember that, vividly recall that more, and be more eager to cite their diagnostic impressions in the report to highlight the consistency. Again, that's not saying that's wrong to do that. But when we talk about equal scales of how much I'm highlighting when records are in line with what I'm saying versus how much I spend in a report highlighting when records were in contrast with what I say, we tend to highlight in our reports and we tend to highlight in our mental conceptualizations of cases more when people agreed with us and more when information is consistent with our expectations than when they're inconsistent with it. And then the subtle area is when information is not necessarily overtly contradictory or overtly supportive and more ambiguous. We tend to be motivated to interpret information in a way that supports our evidence there. So when I said the hospital records didn't have that diagnosis, well, you could argue that that's ambiguous evidence because absence of evidence is not evidence of absence. So we might say, well, they didn't cover it then, or they didn't do the full evaluation of that. That wasn't what they were looking for. So it's more ambiguous. And so I'm going to say it doesn't necessarily contradict my side. And I focus on other bits of the evidence that indeed support my side. Now, I'm going to briefly bring up a study that I'm doing with a colleague, one of my former grad students, Dr. Victoria Houth. She did an excellent study that looked at anchoring and confirmation bias in action. We're still going through the peer review process of all of this. If you're watching, Dr. Houth, I'm sorry for the delays in my revisions to you. We will get it. We will get it out there. But what you see on the screen here is we had SVP evaluators, or people that had knowledge of sexual risk assessment, do a simulated brief consultation on SVP commitment recommendations, indefinite commitment of somebody for sexual risk. And we had them do all the criteria. It said, what disorder does the person have, if any? Do they have a volitional impairment? What is their risk? And do you recommend indefinite commitment for this person, yes or no? And we did manipulate the actual data that were in there that were consistent with a mental abnormality of pedophilic disorder. So we had information in the reports. And so for some people, the ages of the offenses, the ages of sexual fantasies went right in line with prepubescent children. But for half of the people, it didn't. It was about older adolescents. There wasn't any evidence of deviant sexual fantasy, no offenses against prepubescent children. And for half of the people, we also attempted to anchor them into what to expect by putting a diagnosis on the label. We put that diagnosis there of pedophilic disorder. There was no explanation of where that diagnosis came from. And again, in half of the cases, the rest of the information kind of fell in line with that. But in half of the cases, the information directly contradicted that diagnosis and showed no evidence of pedophilic disorder, and in fact, evidence of sexual fantasies away from prepubescent children. And because this is still in the review process, we take all the preliminary findings with a grain of salt, and I'll fast forward through them a bit. But if we saw no anchoring and confirmation bias, we would expect that findings of pedophilic disorder, of volitional impairment, and SVP recommendations would be predicted by the content of the report and not by the label. Now, we did see that people indeed looked at the quality of the report, and we saw that the evidence seemed to fall in line with people's perceptions of volitional impairment. But we saw people's diagnoses be much more impacted by the label. So when they had that diagnosis of pedophilic disorder there, our evaluators were far more likely to diagnose pedophilic disorder themselves, even when the rest of the evidence contradicted. And even more concerning is we saw higher rates of SVP recommendations when the diagnosis of pedophilic disorder was at the beginning, regardless of what the rest of the case information said. This is a subtle example here of anchoring, guiding expectations for what you're going to see, even when the body of evidence would suggest otherwise. Now, those are a number of different cognitive factors that can bias our judgment. Our tendency to try to reduce dissonance by being motivated to support a side, anchoring early contextual information shaping our evaluations, and then confirmation bias, our natural tendency to look for information and to interpret information that supports our preconceived notions. How are we going to address this? it's a mighty strong task. I don't think there is a panacea here, but we'll address a couple of the ideas here in some ways that we might be able to address these things. These are strategies more than solutions. So one thing that's jumped out that a lot of people have asked is, well, if adversarial allegiance is about allegiance to one side or the other, what about just having everything be evaluated by the court? Well, as I said before, that even when we have a court-ordered evaluation, oftentimes we can still be susceptible to anchoring because we get additional context of why an evaluation was requested. And even if we don't have a direct affiliation with a side, sometimes referral information leaks in and shapes our expectations of a case. In our own research, the research that I've done with Dr. Jen Perillo, who's been a principal, also my spouse, who a principal in a lot of the work that I've contributed to with her on adversarial allegiance and forensic bias. We've done studies that looked at adversarial allegiance and also court-ordered evaluations. And if you look at our data on the whole, it looks like court-ordered evaluators tended to find in the middle, in between defense experts and state experts. Well, one, if you just look at the average, it tends to be a little bit state-leaning, which is what we see with court-ordered evaluators. They tend to have a more subtle affiliation with the state. The court is part of the state. So we do see a subtle more state-leaning among court evaluators than the defense as a whole. But in our data that has looked at court-ordered evaluators, even if it looks like it's in the middle, it's actually because evaluators are canceling each other out, where you have a body of court-ordered evaluators that have strong opinions that are pro and biased toward the state, and a number of evaluators that are strongly in favor and in some ways biased toward the defense. And so those averages are actually, it's not because they're in their actual opinions are in the middle. It's because the average of their opinions are in the middle because they're at both extremes and they're kind of canceling each other out there. So one, state evaluators for court can be subtly state-leaning because they are technically working for the state. And we have seen that in some studies. But as I talked about too, bias in these areas is more than explicit allegiance. Subtle context that gets in the way, subtle expectations for understanding why I got an evaluation, and early information shaping what I'm looking for. Now, some specific techniques we can engage in just in our general practice and specifically in forensic practice is engaging in counterfactual reasoning. And the way I phrase this in forensic evaluations is to think like a cross-examiner and to think like an expert hired by the other side. Think about why someone would argue to the court that you were wrong. And you have to do this genuinely. I'm not talking about thinking about softball pitch counter arguments for the other side so that you can knock it out of the park and prove them wrong. It's about looking at taking the perspective of somebody that would disagree with you, not so that you will reject your arguments or what you're thinking, but so that by zooming out, you can reassess whether you are giving the evidence its due weight. And so even if you think about how somebody might disagree with you and you still find one way, your belief or your persistence in that belief might subtly be tempered a little bit more. And if that tempering is appropriate for the evidence rather than being fully convinced by the evidence, then you have reduced your bias a little bit by giving that piece of data what it's actually worth, more so than how you were motivated to see it before. So thinking like a cross-examiner, thinking like an expert hired from the other side can help us zoom out a little bit from our preconceived ideas and thinking about things in a way that would help us see why we could be wrong. This helps us look at some of our bias ignorance areas and helps temper our confidence. We do this often in forensic supervision. So when I've done forensic supervision with my postdocs, oftentimes I'm challenging their perspective on things. What else, what other diagnoses might these be? Or why might this actually demonstrate factual understanding? We're good at doing this for other people. And as I've told my forensic postdocs, by the time they leave the postdoctoral fellowship, The goal when you're talking about being an independent practice is essentially being your own supervisor. It's in terms of consulting with yourself. It's not about being a finished product. Instead, it's more about thinking about and challenging yourself to acknowledge where you might need more information, what other perspectives might there be, and basically helping guide yourself along the way. And by engaging in counterfactual reasoning, you're helping provide your own kind of supervision here by challenging your initial perspectives and making sure you zoom out and look at the evidence and giving it its due weight. Now, there are challenges to this. One is, how often do you do this? Are we talking about countering your conclusions or countering the data? And if we're talking about countering the data, are we talking about countering your diagnosis, or are we countering the forensic opinion, or at what level are we doing this? Do we get all the way to the individual point where we talk about countering the way that you scored each item on the PCLR? The argument would be that would be more effective than not. Resource-wise, there's a question of whether we can do that. Now, there has been some evidence that counterfactual reasoning can reduce overconfidence in other legal psych realms and in neuropsych diagnosis. There's less empirical evidence out there for forensic evaluations, but the principles there apply. Now, what we have seen about counterfactual evidence is that it is more effective when done before making a judgment than after. So doing this, challenging the evidence rather than challenging the opinion, tends to be more effective at reducing our bias overall. The earlier in the process you counter yourself, the greater the potential impact. And that by impacting the early information, you can impact your interpretation of future information. So if my forensic postdoc had decided to look at the first opinion of report early, one thing we would do is then challenge ourselves to look at how this might guide our interview, and look at what might we have done differently if this person had found in the opposite way. And also looking at the report and giving it its value, like why might we agree with this person? Why might there be reasons to disagree? And it's not to say that this evaluation is flawed, but it's to not treat it as gospel, because no evaluation is gospel. Now, another recommendation to reduce bias is to focus your evaluation only on the data and information that is relevant to the legal question, and ignoring all the noise. This is another thing that is easier said than done. And in different forensic questions, different information might be relevant. So one thing I'd challenge you to think about, if we're going to look at the initial report when we're doing a second opinion evaluation, what information from that report actually is task relevant to us? If we're doing a competency evaluation, what information from the past report might be relevant to us? In contrast, what information from that report might be unhelpful? And even more so, what info from that report could be biasing, not only unhelpful, but potentially harmful to us? Sometimes it's hard to really know until we actually look at it. And that is one of the challenges of task relevance. So there can be a number of things that are relevant in an initial report rather than just what their findings were. One, we could be looking at background consistency, the reporting consistency. We might want to look at what the methods were. What records did they have access to? Oh, if I don't have those, this points to other records I can look at later on or pursue. What testing was done? What methods were used in that evaluation? All of this can be helpful information for me. But the complexity of that is I won't know the answers to that until I look. And if I wanted to know some information but not others, it's really hard to unring the bell. If I want to look at a report for certain information and it's not there and I see all this other stuff, no matter how much I want to, I can't really ignore all the other information. I've read it, I've processed it, it's going to influence me in some form or another. And we don't have a real consensus right now of what is and what is not task relevant for different evaluations. We might not always know what will be relevant to an evaluation until we look at it. I would argue, for example, that in most forensic evaluations, I think most of us would agree that knowing the race of the victim, not relevant to the legal question. But if the legal questions centered on defendants' delusions toward a particular race, knowing that victim's race might actually help you conceptualize consistency between the delusions that are reported at the time and why this person might have engaged in this defense, if we're talking about a criminal responsibility kind of evaluation. It's a rare circumstance, but an example of how oftentimes information that's not relevant might actually be relevant for a particular case, and you won't know until you actually look at it. So going back to that initial postdoc assessment there, where we have a forensic fellow doing a second opinion evaluation. Well, the information that my fellow ultimately wanted was less about the evaluator's opinions. She actually didn't want to know that yet because she felt it would be biasing. But it was important in her evaluation to know when the evaluation was done and what tests they did, so that she knew that if this ended up being if cognitive issues came into play, and just 2 months ago this person had engaged in a WACE and an R-bands, it might not be as beneficial, and it might be wrong for her to implement that in that assessment. So she wanted to know what tests had been done, less so wanting to know what information, what clinical impressions the person had, because that information could have been potentially biasing given that she's focusing on present state information. Now, I briefly want to bring up the concept of linear, sequential, and masking here to essentially wrap up. The idea here is that you assess information linearly, looking at each data point individually and then evaluating it individually. So the idea here is, rather than looking at all the information in an evaluation and then looking at the body of evidence and going, all right, what do I think? It's actually sitting as you review a piece of information and saying, how much does this support this finding versus this? How much is it relevant to this versus this? And then going to the next bit of information and looking at that and saying, how much is it favoring this side versus this side? And now with the body of evidence I have, how much do I lean one way or the other? The idea here is that if you examine information individually and you're engaging in all these other processes of counterfactual reasoning and focusing on the data point individually, it decreases its overall weight by having you make a commitment early on to how reliable and valid this information actually is. And so one idea, if you're reviewing somebody's initial report early, rather than just looking at it and not really processing or thinking about it in a way of judging competency, is judging it and looking at the report itself and considering, given the information that's in here about conceptualization, about the quality of the methods that were done, how long ago this report is, how likely is this to lean toward competency or non-competency? And by that, you're making a commitment before you've looked at the evidence, so that you don't, after the fact, or you reduce the risk at least, that after the fact, you look at that information and shape it for whatever side that you want to. I'm going to skip some of this because I want to get to the core of the overall recommendations here. The idea here is that this can limit irrelevant information by focusing only on information in piecemeal. And it may encourage that counterfactual reasoning of why we might be wrong. This is very early on. Linear, sequential, and masking expanded is the version I'm talking about here. It has a strong theoretical development. It hasn't really been examined in forensic practice. And right now it's more about reducing bias from irrelevant information rather than a technique of reducing your bias overall, even for information that is relevant. So one question would be, what is the sequence? We're a long way from understanding what, if there's a particular order that we should look at things. So there's no right or wrong answer to when you would look at that initial report. But the idea here would be to, if when you look at it, evaluating it for its actual value rather than in the body of evidence, looking at it individually first. Now, one last thing I want to bring up is masked referral. And this is the idea of masking us from who actually referred us the side. This is something that's been, well, if we don't know what side gave us the case, we can't be biased toward that side. Well, there's a number of different elements here that cause concern here. How efficiently can we actually do this? Do we have the resources to actually have somebody filter the info to us? Some evaluations might be really easy to unmask. So I know inherently if I get a certain type of evaluation that it's probably from one side. I've noticed in my court-ordered competency evaluations here, even though they're court-ordered, pretty much all of them are referred by the defense. So even if they mask them, I'm pretty much going to be assured that it came from the defense just because of how things play in my district. Most clinicians, in fact, feel that they can unmask different evaluations. Now, another moderate masking idea would be, rather than having purely masking from the referral source, could be what we did with my postdoc here, where we masked the information by having it filtered through a third party, me. She wanted to know what testing had been done in the initial report, but didn't want to know the evaluator's conclusions. I can review that report and tell her what has been done without her having to look at the other noise that she didn't want access to. Now, on the one hand, this is promising, but on the other hand, that means now I make the call on what's relevant. I make the call now of what to tell her. So my own biases can then filter and influence her biases. So these are perhaps strategies, but they're not panaceas because bias can still get in the way. So my take-home messages: bias is not just about our conclusions, it's about our process of interpreting and selecting evidence. It comes early in the evaluation, so we need to address it early. There's no strategy that's perfect, but these strategies can be used together to help each other incrementally. And last but not least, in situations where it could be ethical, perhaps we can help each other if we want to filter out the noise by helping each other. This is easier in the supervisory process, where I can work with my forensic postdoc and look at the information and filter out what they're specifically looking for so that they don't get unduly influenced by other noise. And perhaps a tit for tat kind of situation, they could do the same for me. But that's all in different contexts where there is where there's ethically appropriate to potentially look at some of this very sensitive information. So I'm happy to address other questions about bias. I will leave the QR code in the chat here a bit. If I can multitask to a limited degree here, so I am going to also type my email and I'll be happy to answer any questions that anybody has. Oh, actually, I actually don't have the ability to type to everybody. So I won't be sending my email to this, but you can find it. It's on the UNM website. I'm happy to answer any questions after this talk or anytime later on. And I'll now throw it to the Q&A.
Wonderful talk. Thank you so much, Dr. Perillo. Would you like me to enter your email into the chat for people? I think I'm
sure. Actually, that would be great. Yeah.
Okay, so I'm entering that now. And then I did, we got a few comments at the end about how important and wonderful this talk and this information is. And a couple people just wondering how they can access the PowerPoint for today's presentation.
It should be posted for anybody that has access to the past ones. It should be updated within this week.
Okay, perfect. So we did get some questions and comments in the chat. One question is, what would you suggest doing in an evaluation where the defendant is unwilling to share any information about their legal strategy in court or how they would work with their attorney, and the only information available is from their attorney? I would assume that if we anchor our opinion in what the attorney is saying, it could be quite biasing. How much weight should we give to that information in such a situation?
I'm assuming this is about a competency evaluation in that particular context. You know, in the general scheme of things, of course, more data, especially if it's more relevant data, is better than less data. And in this case, having the defendant's perspectives on legal strategy or how they would work would be very relevant information to assessing competency. So we would want that information. But of course, if we're only relying on a particular lens from the attorney, well, that is important for us to acknowledge when we are assessing the information that they're giving us. Now, some of that information might actually be very helpful to us if, for example, this past defense attorney has worked with several people with mental illness, and their expectation or their framing is relative to other people with mental illness or relative to other people with cognitive deficits. I have found to be struggling with this person in a certain way. That's another data point that is important for us when we're factoring into how much of this information or how much of this judgment is the person's abilities versus attorney expectations. That could be relevant, that could be not. But I just bring this up as an example of, you think from as many perspectives as possible. If the defense attorney says, I can't work with this person and they can't because they don't seem to understand or recall anything we talk about. Well, why might that be? Well, it could be that they don't understand. It could be that they're very distressed and just tuning this out. It could be that the alliance with the defense attorney was broken early on and they're resisting and not wanting to work with you out of their own volition. It could be that the person is exaggerating deficits. There are a number of different evident options there. The idea is whatever other information you have is looking at what is the likelihood that any of those alternatives are true. So rather than just looking at what is the likelihood that this attorney's perspective is reflection of the truth, it's making sure that you identify the other potential explanations, and you're looking at the likelihood of all of those explanations being true. The idea is once you form your opinion, you're not forming your opinion by leaning one way and then finding that, oh, this seems like it's right, so it's right. It's by acknowledging many different options, and then through the process of gathering as much data you have, crossing off several others that seem increasingly unlikely based on the data that you have until one viewpoint remains.
Thank you. Another question here. This person says, I see a lot of omission bias in my work, wherein psychologists are reluctant to provide a diagnosis. This can be consequential to the client, but from my experience, it is not a lack of information to make the diagnosis, but more a lack of diagnostic skill of the clinician. What can you discuss about omission bias and how to counter it in oneself and colleagues?
I'm seeing the question here. I'm going to process this a little bit. About whether it's a lack of diagnostic skill. I've seen it sometimes too on the side of, I've heard it from some forensic evaluators, more of a protective mechanism. If a diagnosis is not necessarily required, that if I give the more specific information I give, the more it can be picked apart. And so if it's not required, I'm not going to include it. This is another, though, example of this perspective taking of, we have a natural tendency, if we see conflict between a defendant's report and collateral records, we have a tendency to overinterpret collateral records as being the actual truth, when in fact they're prone to the same documentation biases that we are as humans. And so it's another account that could be very valuable, but it could also be biased. And so thinking about when you review a report, well, how relevant is this report? How much does it support a finding this way versus this way? And why might there be some reasons that it doesn't fully support a finding of this way or this way? And so if you look at a report that is not whole and is omitting diagnosis, and you've determined from other bits of the information that it's more a product of either the evaluator or their process, rather than strategy of omitting from the report for security reasons, that is a reflection of you of how much weight you're willing to give that report. That it can be helpful information, it can be helpful clinical perspective, but maybe instead of me looking at the importance of that information as like a 9 on a scale of 1 to 10 of importance, maybe now it's more like a 6. And this is the whole goal here is about tempering the evidence that could suggest or skew us one way or another. Challenging yourself to look at the flaws in the rest of the data helps us temper how strong that evidence actually is. So by putting little pinpoints into each little data point there. It's not about throwing away all the evidence. It's about making sure that we don't overemphasize certain bits if it doesn't merit it. And in a situation where you've determined that it looks like, based on my clinical expertise, this evaluation missed some important pieces, that can be helpful in you not treating the rest of the information there as unduly influential on you.
All right, a couple more questions here. One is, can collaboratively developed referral questions reduce bias?
Collaboratively developed referral questions. Well, I'm assuming the idea here there is that you get the referral information that then is not necessarily skewed from one way or the other. It's the product of two different sides in the case. That would seem to reduce particular forms of anchoring. The question is, when you get that referral information, chances are of it becoming a impartial referral information is pretty low. It might be less skewed one way or another, but it's still probably one side's going to win out a certain way, or just the way that things are worded or framed might lean one way or the other. So at least intellectually and in line with our cognitive theories here, could it reduce bias? I don't see why not. I think it has a compelling case there. Would it eliminate framing and anchoring? I'm pessimistic on that. So I would say that would be helpful, but it would be important for us to acknowledge we still could be skewed from that, so that we don't automatically go into an evaluation with a collaborative referral, then assuming that we have objective information. Because now then again, we're prone to bias ignorance if we overestimate our objectivity going into the evaluation.
Okay, and then we have one here that says, how much should we inform the court about these biases, given how often they agree with our opinions and competency to stand trial evaluations versus getting beat up on the stand regarding this?
My argument has always been that by acknowledging that I could be wrong or that I could be biased, that makes me dig further. And that once we think we're fully right and that we're not biased, we stop looking. I'm more skeptical of the evaluator that is that describes themselves as objective and fully confident and does not acknowledge tempered expectations that are right there. And I think it's okay to admit to the court that, yes, I could be wrong, and this is what I did to check that. Now, could I still be wrong about that? Sure. But this is what decreases the odds of that. And that's why that is what I did to then examine whether or not my interpretation of this was wrong. And so I don't think you ever get to 100% in your own mind, but being reasonably confident by eliminating other possibilities, it's important for us to acknowledge that we could be biased, because if we don't, we're not checking it.
Okay, great. Do you have time to answer one more? Or
sure.
Okay, just one more here for you. So any suggestions for how to persuade agencies to adopt a blinding approach when that's not what we've always done?
A lot of this gets back to some of our program evaluation 101, or looking at different types of resistance. Some of it gets into like, what is the reason for the resistance, or why might there not be buy-in? Dr. Jen Perillo and I have done some preliminary work on surveying attorneys about mask referral, because one of our things of let's slow our roll here in terms of recommending mask referral is we're saying this is the way to go because it reduces our biases. Well, it also can risk taking agency away from attorneys who want to hire a particular person or want to vet a person before they actually accept them. And so what is the reason for any kind of resistance, and looking at what the benefits of this are going to potentially be. Another big issue is resources of having somebody that can filter the information and training people on what is relevant information, what is not, and how to communicate that information to evaluators. This is an area that we don't really have much knowledge in. Most of the discussions about masking referral source have been more anecdotally. This is what I do in my practice. This is what I do in my practice. We need more people. There are not many people, I think, that are doing this, but we need those people to be loud and talking about what they do. Not so that we follow that, but so we at least have an idea of what's going on so that we can then down the road develop best practices here. But if I was talking to an agency about the benefits of mass referral, just talking about this idea that we're trying to remove ourselves by being unduly influenced by what side hired us. We are human. And when we know the side that has hired us, we tend to try to help that side. And by not letting me know who referred the evaluation, it helps me prepare to do the evaluation for either side.
All right, great. Thank you so much. And so that wraps up today's talk. Thank you all so much for attending. As a reminder, for next week's talk in this series, we will have Dr. Michael Gottlieb and Dr. Jeff Youngren, who will be discussing ethical considerations surrounding multiple relationships in forensic practice. So thank you so much, and I hope you all have a wonderful day.
Thank you.
Thank you.